Good morning, dear all. Myself, Dr. Ujjwala Bangare, Head Department of Information Technology. Welcome you all for this webinar titled Digital Data, Personalization and Privacy. I express my sincere gratitude towards the IST chapter of K J Somaiya College of Engineering and our principal, Dr. Shubha Pandit, who has encouraged us to conduct such kind of informative session. And I take the opportunity to welcome our speaker, who is a giant from the field of cyber laws, Mr. Vijay Shankar Naavi. Welcome you, sir. And thanks for sharing your valuable time with us. And a request to Professor Dipti Patole to introduce our speaker this session. Over to you, madam.
Thank you, madam. Good morning, all of you. It gives us immense pleasure to have Mr. Naavi sir as guest speaker today. I'm trying to cover his introduction in very short span of time, but that's not enough, but still I'll try. He's author of first book on cyber laws in India, which was titled Cyber Laws for Every Netizen in India. He had published first ebook on cyber laws as Cyber Laws IT Act 2000 and beyond. He is also author of a Kannada book which is named as Antarjala Aparadhagalu. Please forgive me for mispronunciation, which was released in 2005. He is also having other books under his authorship, Cyber Laws for Engineer, then other ebooks, which were ranging right from 2005. He is pioneer for the concept of Cylocom, which promotes use of voluntary cyber law compliance program by the industry. And he is currently running program which is creating mass awareness of cyber law in Karnataka through Karnataka Cyber Law Awareness Movement, KCLAM. He has also created Kannada website which is making people aware, which is labeled as navika.org. He is also visiting and guest faculty at various institutes such as Nalsar University, Hyderabad, the School of Excellence, National Law School, Bangalore, and many more such institutions. He had been always also involved in training Tamil Nadu police in cyber crimes and assisting the police in cyber evidence collection and management. He is specialist in HIPAA High-Tech Act consultancy and is a premier HIPAA auditor in India and overseas. And this list is not ending anywhere, but he has exhaustive experience of 40 years with many aspects of business and with sound academic grounding. He is also part of many awareness programs which are always going on. He also keeps on writing blogs on his website, which is naavi.org. You can visit that. So we are very fortunate to have him with him. I'm not taking much of the time from the session. I would like to invite him for delivering the talk to us and hope we enjoy the talk and we get enlightened from the talk. Over to you, Naavi, sir.
Thank you, Deepti, and our friends. Let me share my screen so that I can start off. Just a minute. Good morning, friends. I hope you are able to see the presentation now.
No, sir.
Maybe you can reshare it because what we can see is your desktop. Here.
Yes, sir. Now it is visible.
Okay. Okay, friends. So thank you for having given me this opportunity to interact with the engineering faculty on a subject which is privacy. And in a way, privacy is a sort of topic which has become very much important today. It has emanated from the legal field, but gradually the technology also is getting engulfed with the discussions on privacy. So it is good that you have decided to have some kind of a information sharing at a time when India is on the threshold of introducing a comprehensive data protection law in India. So what I would like to do is to go through the relevance of data protection law to engineering faculty for a couple of minutes, and then get into the convergence of privacy protection as a responsibility and data protection. And thereafter, I will try to introduce the essentials of the Indian Data Protection Act. I hope we will have a lot of discussions at the end of it, or anyway, anytime during this presentation. If you feel you have a question, please go ahead and raise your query so that I will be able to take it up immediately. Okay. So to start with, when we talk of the relevance, we are all aware of the term called information security and also cyber security. Of course, when we talk of information security, we talk of information being protected in terms of confidentiality, integrity, and availability, the CIA principle. And the term cyber security is often discussed along with information security as if they are interchangeable. But normally, cyber security focuses more on the security related to external threats like the attacks which are coming from internet and so on, whereas information security is in a way focused into what we have as information asset within our organization. So some brief, some very fine distinction can be drawn between information security and cyber security. And now we are talking of one more term called data security. Now the question is whether all these different terminologies actually lead to different things, or they all converge into a similar meaning. So in that context, if you look at data protection, we have a question whether data protection is different from information protection or protection against cyber risk, and whether data protection is more than information security or less than information security. Because as we know that in the industry, we have designations called information security manager or information manager. We will have CIOs, CISOs. And we also have a category of profession called, say, chief compliance officers and chief risk officers. And there is a need for us to understand what is the role of these different industry professionals, because there are two educational, say, foundations through which people land up there. One is, of course, the law. People who study law end up as, say, compliance officers in an organization by studying whatever is the legal compliance required for an organization. Whereas IT people end up as information officers, CIOs, and CISOs. Now, there are also people who graduate from the management cadre, and today management has not focused too much on the data governance, but definitely in the days to come, there will be a cadre called data governance managers. And again, the question is whether data governance is bigger than information security and other things. We will keep on debating. So there is a role in an industry for legal people, technical people and managerial people, all of them converge in the area of data protection. And we have a new generation of profession called data protection officer. And this data protection officer could come from a legal background or could come from an engineering background or even come from a management background. That's why data protection is actually considered as a techno-legal subject to which both people from law and in information technology have equal claim, provided one learns the domain of the other. That is, it's a cross-discipline kind of an understanding which they have to have. Now, as a faculty in an engineering college, I am sure that you are running many courses on information security and cyber security. Now, the question is whether data security should be made integral to that part of the activity, or probably you should have a separate course on data protection. So these are some of the thoughts which come to my mind when I am interacting with you as engineering faculty. Now, the other question is, what is the status of data protection law in India? Is it already operative, or is it somewhere in the distant future? We will address all these things during our discussion. And I would like to see that all of you become conversant with the background and appreciate the importance of data protection as a field of study. The actual act, of course, one has to read it a number of times. You have to continue the study, and that is a continuing education aspect. Now, when we know privacy, privacy is a human right concept. That is, people say that if you are a democratic society, right of privacy should be there. It is a fundamental right and so on. Whereas data is a creation of technology. So question arises, how does this protection of human right called privacy protection becomes important to an IT company or an engineer? Now, when we say an engineer, we are looking at the career which can go into software development. Some of them may call themselves tomorrow as data scientists and data analysts. Now, how are these people involved in the protection of right to privacy, which is a human right concept? The question is, let privacy activists take over that responsibility. Why you are asking me as a CEO of a company which is actually a commercial organization, which we want to do business, we want to use technology for making money. In what way privacy is relevant for us is a question which arises. For understanding this, we need to first of all understand this concept of privacy. See, without understanding what is privacy, we cannot appreciate privacy protection, and then how, as an IT company, I am involved in privacy protection. Now, basically, privacy is a concept which is close to freedom. Basically, a freedom to remain aloof, you can say. That is, physically, I have to have the choice of understanding who can be with me and who need not be with me. Okay, this is the fundamental concept of privacy. And we identify something called physical privacy, where we want to maintain certain distance with somebody else whom you may either would like to be associated or not. However, privacy is not limited only to this physical state of a person. How far is my next person? Is it 3 feet away or 5 feet away or 2 feet away? That is not really the crux of privacy, though that is also called physical privacy. What is more important is privacy as a state of mind. So it is more psychological. That is, in my mind, I should feel that I am free. I am not influenced by somebody else. Then that is freedom of mind. Okay, that is the state of mind of being left alone. See, many times we are in a crowd, but we don't feel that our privacy is threatened. We are in a local train and people are around me, but still we enjoy that. Maybe you may be humming a music and you don't feel that your privacy is threatened. But there are situations where if you are left alone, you are not happy. That is, you want people to be around you. So privacy is such a complicated state of mind that physical privacy has got no meaning. Only the mental state of mind is important. I may feel comfortable with the crowd. Sometimes I may not be comfortable without a crowd some other time. Now, with such a concept, which could change from one person to another person, because somebody is an extrovert or an introvert, that is one of the reasons why different people have different states of mind. And even for the same person, this state of mind is a dynamic state. It may not remain the same. That is the right we are talking of privacy. And the question is, how do we make a law to protect this privacy when there are 130 crore Indians and each of them have got their own states of mind, and within each such state of mind, things will be changing. Now, making a law is one, enforcing it is another. So this is the challenge in the data protection law. If you feel that the Indian government is taking years to pass a law and they are very inefficient and so on, one of the reasons is that making a data protection law for 130 crore people whose state of mind we don't know is a very big challenge. Of course, this is a challenge across all countries. In fact, in India, yes, very serious discussion on data protection started with what we call as the Puttaswamy judgment, which is a Supreme Court judgment in a case in which there was a petitioner who was Justice K.S. Puttaswamy versus the government of India. And initially, it was against Aadhaar, and then it went into the privacy as a fundamental right debate. So on 24th August 2017, Supreme Court came up with a very important judgment. What had happened before this is, there was a petition in which the use of Aadhaar as an instrument of identifying the beneficiaries of various government programs, etc., was being discussed. At that time, same Puttaswamy had filed a petition saying that use of Aadhaar is a violation of privacy of an individual. Now, at that time, there was one Supreme Court judgment of 1954, which was called MP Sharma versus Satish Chandra, where Supreme Court, a 8-member Supreme Court bench had held at that time, 1954, that right of privacy is not a fundamental right under our Indian Constitution. So today we speak of Indian Constitution. There are two views that people say Indian Constitution is sacrosanct and whatever is there must be followed or something like that. But this Indian Constitution itself has undergone a lot of amendments, and Supreme Court also have interpreted different aspects of the Constitution at different points of time. So it is actually an instrument which has many dimensions of interpretation. So this 1954 judgment of 8 members of Supreme Court had held that privacy is a good right, but it is not to be considered as a fundamental right in India as per our Constitution. To counter this, the Puttaswamy bench, the current bench of Supreme Court, they constituted a 9-member bench, and they wanted to actually declare right of privacy as a fundamental right. Okay, so that's why what Supreme Court did was that the bench which was hearing the Aadhaar was asked to stop its hearing, and then they constituted a 9-member bench it was evident from the beginning that the very purpose of constitution of this 9-member bench was to overrule the 1954 judgment in the MP Sharma case. So this went on for some time, and finally the 24th August 2017 judgment came, which said that privacy is a fundamental right under Indian Constitution, under what is called the Article 21, right to life and liberty, and it has to be protected. So that was the thing. And they also said inter alia that the MP Sharma judgment is overruled. Okay, so that was the crux of the judgment. Now, what did it imply to the society? This judgment, which said that right to privacy is a fundamental right, also meant that it is a right like any other fundamental right, and it is subject to the power of the government to impose reasonable restrictions through a separate law, so that the government was could perhaps frame any law in which certain things could be changed. In fact, Article 19(2) of the Constitution itself indicates certain aspects of reasonable restrictions, which are always imported into an interpretation of any fundamental right. So the Supreme Court judgment meant that right to privacy is something which is to be respected as a fundamental right, but it can be subject to reasonable restrictions. And such reasonable restrictions could be imposed based on the interests and sovereignty, integrity of India, friendly relations with foreign states, public order, decency and or morality, contempt of court, defamation, and incitement to an offense. These are the 7 principles which are available under Article 19(2), stating that for any of these reasons, government can pass a law and abridge the fundamental right, including the right to privacy. So this was the implications of the Puttaswamy judgment. But basically, all constitutional obligations are considered as a direction to the government that wherever you want to abridge, then you need a law. But the law should be drawn in such a manner that it should be proportionate to the requirement. It should not usurp more powers than what is required. So some of the laws passed may be subject to the scrutiny of the Supreme Court, like whether the law is good or bad. In fact, if you remember, in Information Technology Act, there was a section called Section 66A, which the Supreme Court on a later day held that it was violative of the Constitution, and therefore it has to be scrapped. So judicial overriding of any of the law is always possible, and even if a law is made by the government to abridge privacy, it's always subject to the judicial scrutiny. Even after the Data Protection Act is introduced by the government, there is no doubt that it will be challenged at least once in the Supreme Court. Now, apart from this Puttaswamy judgment, which was on the constitutional arena, there was a Kerala court judgment which said, it was actually a Woman Chandy case, where the court made a mention that this new recognized fundamental right of privacy should not be restricted only as something against the government. It should be held even against the private organizations like the companies. And therefore, privacy protection became the responsibility of the industry in a way by judicial interpretations. But what is important for us to also recognize is that while there was so much of commotion on this declaration of privacy as a human, as a fundamental right, the entire judgment, 900 and odd pages of the judgment, they did not go into a proper definition of privacy. So they said privacy is important and privacy has to be protected without actually defining privacy. It was left to the interpretations. Of course, whenever there is a judgment, the judgment ends up with an order. In this case, the order was that right to privacy is a fundamental right under Article 21 of the Information Technology, the Constitution. And it this overrides the MP Sharma judgment. That was all the order which was relevant as far as this judgment is concerned. But before arriving at this one-page order, the 9 judges had put in their views on various aspects, including arguments like this is what this party says, that's what that party says, this is what we feel, kind of a thing. We go into that plethora of views expressed to derive if there is any definition of privacy. In this 9 judges report, Justice Chandrachud in his part reiterated that the right of privacy is a desire of a, or privacy is a desire of a human being to be left alone. Okay. But he also tried to bring in a linkage of this right, which should be considered as a human right, a right of a person, that he should feel mentally that he is left alone. He linked this to the data and information. What he said was that we are now living in a society where information is an integral part of our life. So whatever we call as right to be left alone cannot be easily violated, can be easily violated by the information. Like if you are doing something and suddenly there is a WhatsApp message and there is a notification sound on your mobile, definitely you will get disturbed to some extent. So he tried to say that we are living in an information dominated world, and therefore this desire of a person to be left alone cannot be protected unless we also protect him in this digital world in which information is there, and this information has got certain specific characteristics, like it can travel in the speed of light. It can be duplicated in the sense that information with me can be shared with you and I will not lose anything. You will also have a copy. Therefore, and additionally, if I have got some information, you have got some information, the two can be combined. So he identified these 3 characteristics of information, which is non-rivalrous, that is, I can also have, you can also have. It is invisible and travels at the speed of light, and it is recombinant, that it can be combined. Now, using these things, he said that we need to recognize what is called information privacy. That is, protection of the human right of privacy has to be extended to some kind of protecting the information through which the state of mind of a person could be affected. Now, in this context, it is now more or less is a settled law that what is required is an individual's choice of how his personal information has to be dealt with, has to be captured whenever that individual information is passed on to another person, and that preference is called the consent, and that consent needs to be adhered to by the person who is having the information. So in that context, today, if you want a definition of right to privacy in our IT arena, we have to say that right to privacy means a right of self-determination of a living natural person on sharing of personal data, specifying how the personal data may be used by the recipient or shared with others. I am consciously using the terminology living the natural person because the right to privacy is recognized as a fundamental right of an individual who is a natural person. And secondly, all the constitutional rights are available to a living person. Dead persons have different rights, but this is a living person. And then when we say we have to capture the preference, consent, and then adhere to it, then on the death of a person, the instructions he had given earlier becomes a little gray because once he dies, whether the earlier instructions are continued in its effectiveness or not is a question of law. There are, of course, instruments called will, which a person will write when he is alive and say that after my death, this should become valid. But in India, we have got this Information Technology Act, and under Section 1, subsection 4, the document like a will, if expressed in electronic form, is not considered recognized. So there is some kind of a restriction on how we transpose the instructions given by a person during his lifetime to a time when he is no longer alive. So the consent, it is, if it is considered as a contract, which is one of the aspects of this law, cannot be transmitted from a living status of a person to his deceased state. And also these citizens' rights are normally there only as long as they are alive. There does not seem to be a law which recognizes a dead person as a citizen. He can only be referred to as a past citizen. So living natural person, when he shares some information to another person, he can say that you can use it only for this purpose, not for any other purpose. That is the conditional sharing of information, and that is what is called the right to privacy. Corporate data is not a subject matter of privacy. It is a subject matter of security. That is one of the difference between information security, cyber security, and personal data security. Say, corporate information is about a company. Business information is about an activity related to business. They are actually not considered as personal information. In addition, we sometimes have environmental information. For example, a company might have put up a weather station, and weather station collects a lot of information. This company has spent money to collect that data. Now, this data is neither personal nor corporate. It is about the environment. So privacy does not address these kind of non-personal data. Okay. We will come to a small distinction in our law later. So that is why we are looking at the protection of personal information of a living natural person as the crux of privacy protection. There are some international laws such as Singapore law, which protects the personal data for about 10 years after death. HIPAA itself has some protection up to 50 years. So there may be other countries having a different law. But in India, we should say that this applies to the living natural person only. Even the GDPR of EU, which people look at as an important landmark data protection law, restricts its coverage to only living natural persons. Now, if a person is deceased, and if there is a personal information associated with him, that is still protected, but under a different right, which could be called as right against defamation of a deceased person. So the relatives of the deceased persons can always try to protect some aspects of that information. So we need to understand that the right to privacy and whatever we discuss as data protection is related to an individual right and not to a corporate right. But such a right always has inherent conflicts. Right to privacy has a conflict with right to information and also right for security. Now, whether security itself is a fundamental right, we can always debate. I personally feel that if we don't exist, then obviously there is no question of privacy, right? So right to security becomes, in my opinion, a priority over right to privacy. And if the government has got a duty to protect the citizens, right of the government to protect the security of a citizen should be considered as a duty which should override the right to privacy. Of course, this is not necessarily the popular view. People don't want government to infringe on privacy for various reasons. When there is a CCTV on the camera, people, on the street, people are complaining that the government is surveilling against the citizens. But whenever some crime takes place, citizens will immediately ask, is there any CCTV camera from which we can find out something? So the government or the law enforcement has a kind of unenviable task of having surveillance, but still saying that we are not going to infringe on the privacy. So this debate is for a different forum, but I will restrict myself to the right to privacy now. Now, if you consider that information privacy or the right of choice is the definition of privacy, then we should also accept that there is, if you take an individual and ask him, okay, you tell me now what information you are giving me and how I should use it, we should recognize that the subject himself has got one set of things which he knows about himself. He may also have some information which he may not know. So what he can share is only what the data subject knows. Some of that information he may say, I'm keeping it confidential, I'm not giving it to you, and therefore leave it out. But I'm going to share some of the things under a condition. That is what is the conditional sharing part. In addition to this confidential part and the conditional sharing part, there may be some information which is already in public, which there is no point in you are asking me to put conditions or something like that. So the information that a data subject knows and which has to be part of this data protection consent can be broken into confidential, public, and conditional sharing. Beyond this, there is some information which we don't know about ourselves, but some of that information may be known to, say, criminals who have stolen it from me without my knowledge, some of which might have been gathered by the government through surveillance, some of which companies might have created as their intuitive ability of combining various public information. So if every day my Google map shows that I am going to a particular pub, definitely a company will perhaps profile me as a person who is interested in liquor, and they may send me some advertisements on liquor. That is a kind of profiling. And maybe you are going to the pub not to drink, but actually because you are employed there as an employee of, you want to sing music or something like that. But the company may hold a profile saying that you are a good prospect for selling liquor. So such profiles, some of which may be true, some of which may be untrue, but still that is gathered by companies. And again, you cannot tell a person what kind of profile he has got. So controlling the profiling is a difficult part. It's a speculative part. But this data protection law sometimes tries to do that. So we should understand the limitation of data protection regulation, that consent may not be possible in all circumstances. And also, if you obtain the consent online, then the question of authentication comes into being, because in India, we have digital signatures as the means of authentication. And when you put I accept or something like that, a click of a button, click wrap contracts are not recognized in India. Therefore, authentication of a consent is always a problem area. And there will also be some kind of a contest on what kind of things require consent, what kind of things do not require consent. For example, in the case of employees, we often debate. Now, the company wants to actually have background information of the employees. They want to evaluate the employee, not only for performance, even for his integrity and other things. So whether you need a consent for that, or is it something which you cannot ask for consent, is something which is a limitation of the data protection regulation. And intellectual property rights may also sometimes interfere with the right of ownership of data, therefore may affect as a limitation of a data protection regulation. Now, the industry through this law has been asked to look at a concept called privacy by design. That is, even when the software is being developed, at the architecture stage itself, you should have something related to protection of privacy. So privacy should be part of a design, is an expectation of the lawmakers. Therefore, a software that collects or processes or shares or destroys personal data should have such say features whereby the software, like a person, should be able to look at the privacy requirements, in the sense that if the law says consent is required before collection, the software should ensure that it is possible to collect the consent. Otherwise, it should not progress to the next step. That kind of designing of software is what is called privacy by design. That is, by default, if the data subject who interacts with the software does not do anything, then his privacy should be protected. If the software wants him to share any data which is relevant to privacy, then there should be this concept of opt-in. That is, for everything a permission should be asked, and you have to obtain the permission. Permission should be recorded. This is what is called privacy by design at the software stage. In the Indian law, we go one step further, that it is not enough if you have a technical architecture where privacy is protected by design, but you should also create a policy document, and that policy document should be shared with the regulator. In a way, it is a commitment of the management that is expected in the Indian law. So if you are a software engineer, then along with learning coding, you must know what are the limitations. Today, security by design is a concept which you must have already absorbed. You tell people that when you code, you please remember that it should be designed in such a way that unauthorized access is not easy, or unauthorized access is prevented by a gateway. Somebody else will allow a person to come in or go out. Now that is security by design. Now the security by design concept is further expanded to say that all aspects of privacy protection as required under a data protection law should also be there by design. This is also important for data scientists, because data scientists, big data people, they do profiling. So I already said that profiling is an aspect of privacy. Now, if law says profiling should not be done without the consent of a person, then which means that the data scientists, when they design an artificial intelligence program or developing a machine learning, they should also know what is this data protection law. This is the basic need, requirement, why an engineer has to know the general aspects of this data protection law, without which he will not be able to develop a quality software which is privacy compliant. And a software which is not privacy compliant is not a quality software, because if you let that software be used by a user, you are actually driving him to some kind of a legal issue. It is like developing a car with a brake which may fail. And obviously it is your responsibility, because you are selling it to this users. And if they meet with an accident, you should take the responsibility. Same way, software people need to understand privacy and incorporate it in their design. There is, this is the need by which the engineering people should be taught about this data protection law. But when we talk of this privacy by design, do you have any questions up to what we have discussed now? Please raise your hand if you want. See, what we have discussed so far is the legal background of privacy and why privacy has become relevant to the engineering community, and therefore as engineering faculty, why you should incorporate it into your education stream, etc. These are the things which I have discussed so far. If you have any questions up to this, you are welcome. Okay, whenever you have a question, Yogita, do you want to say anything? Otherwise, you please raise your hand so that I will be aware of what is going on in your mind. If you want, you can also put it in the chat box from time to time. I will try to look at it. Okay. Fine.
Yes, participants, if anybody is having any question, please put it in the chat box. Yeah, so one question is there. Shall I read it for you?
Go ahead.
Yeah. how mandatory it is for corporate to be data privacy compliant? That is the question asked by
Yeah,
Purnima
good.
ma'am.
Good. Anyway, I'm going to discuss about it in detail. Both there could be financial say penalties, as well as on occasions it may result in criminal punishments. So that is what you must consider as a mandatory nature of the data protection. I will go into it in greater detail. Okay, fine. Now, when we talk of privacy by design, when I say data scientists should understand law, etc., there are certain challenges in that. I do understand that it is not always easy. Now, because the technologies and lawmakers do not have a common understanding of what is data, what is required to protect privacy through data protection, what are the limitations of technology, or even what are the limitations of law. So because of that, we have problems. For example, if I ask a question to you, what is data? Now, technology persons may have one perspective, legal people may have another perspective, business people may have another perspectives. For example, technology people look at data as a binary expression. For a technologist, zeros and ones is what comes before the eyes when we say data. But people, at least in the data protection area, we immediately go into the realms of it is my data, your data, personal data, corporate data. So we look at data as a property. And in the corporate circle, there is a monetization of data, and data is actually money. And again, another aspect of property which has got a value is that it is considered as an asset. Now, these are some of the normal ways by which we describe data. But what is important for us to recognize is data is actually an experience by a human being. When we say data is text, data is a sound or a video, or we say that, okay, one person is standing here in a suit. Now that is actually an experience, it's a visual experience. I am seeing the picture of a person standing there. Now, actually, this is nothing but data. If you look at the code of this particular page, there will be some data which actually, when rendered through a computer, which is running on Windows, which is running a PowerPoint presentation, it shows that the data as this picture of a person or these various hexagons which I'm talking of. This is what I call as data as a human experience. With all these perspectives, one thing which all of us can agree is data is an enigma. Nobody can understand data. Different people have different perceptions of data. And with that, the technology person has to protect the data, and the law person expects it to be protected in a particular way. So binary, for example, I've given you an example here. This is a binary. Now, this, if you are using with an appropriate application, in an appropriate operating system, using an appropriate software, you may see it as data, you may hear that data, you may touch and feel data in some form, you may smell data if such things are there. Today we are into the metaverse area, so we may have smelling and touching available through various devices. And if you connect a lead to your mind, maybe you can hallucinate data. So binary is an experience. It is irrelevant what zeros and ones you have. What is relevant is what does a human see out of it. For example, this particular binary, if you take an ASCII view, it may convert into a sentence, data is in the beholder's eyes. This is a statement from the theory of data, which I am proposing. Data is created by technology, but is viewed by humans. And data is in the beholder's eyes. Data is not there in the form of zeros and ones in the hard disk. Data is there in the beholder's eyes because what is there in the hard disk is an instruction to a hardware, instruction to a software to render it into a screenshot, and that screenshot comes before my eyes, and therefore that is what I call as data. So the ASCII view of this binary is data is in the beholder's eyes. The same thing, if I take a decimal view, I may get something different. If you may look at it as a single binary number from here to here, and it may be having a huge numerical value. Now, is this correct? Is this correct? Or both are correct? So when you say this is a document, you must say this is a binary expression. If you use it, if you view it as an ASCII, you will get something like this, a text. If you view it as a decimal, numeric, you may get something like this. Or if you want to be innovative and put commas for each of these kind of sets, you may have different kind of numbers also. So this is what I call as an unreconcilable difference between interpretation of data as a lawyer and as a technology person. To overcome this, the Information Technology Act, which was enacted in the year 2000, 20 years back, had thought of an amendment in the Indian Evidence Act called Section 65 capital B. I would like you to explore that. And according to that Section 65 capital B, no electronic document will be accepted as an evidence in a court of law unless a human being comes up and says, I have seen this electronic document and I have tried to experience this in a Windows computer with such a thing, and it says this is the experience I have got, and I am certifying that this document translates into this sentence. And that person has to give a certificate that is called the Section 65B certificate, and only then the data will be taken as evidence in a court of law. So the lawmakers of Information Technology Act had foreseen the possibility of this differential interpretation and then made some kind of arrangement out of that. But it took another 15 years for these courts, including Supreme Court, to recognize the value of this Section 65B. That's a different history. Those of you who are interested in this, please explore Section 65B in my website, naavi.org. You will get something very interesting. So this is an essential problem, and we need to all join hands in developing a common understanding of techno-legal view of data. Then only we will be able to understand the law. With this background, if we look at the Indian data protection law and take a bird's eye view, there are certain things which I want you to keep in the back of your mind. I know you are not lawyers, so you don't have to go very much deep into it, but this knowledge is essential. Now, the personal data regulation in, do you have any questions up to this before I go deep into this law? The interpretation of data, the difference between the technology interpretation and the legal interpretation. Okay. Now, if we go further into the regulation, personal data regulation in India has evolved. This ITA 2000, which was enacted with effect from 17th October 2000, was amended in the year 2008. And finally, on 27th October 2009, a section called 43 capital A became effective. And this particular section had certain rules which became effective actually on 11th April 2011. So this section 43A is presently available in its full form from 2011, that is 10 years. And this 43A is a concise form of the current Data Protection Act, which is in the form of a bill in the Parliament. people are complaining about this act, which is presently referred to as DPA 2021. It may become 22 because it was not passed in 21. Now, people are raising questions on DPA 2021, including so-called informed people in NASCOM and other things, but they are all forgetting that DPA 2021, which you are objecting today, is nothing but something which is already contained in section 43A 10 years back. For 10 years, this law has been effective. You never recognized that there was a law. You never complied with it as a law. Now, when a new law is being proposed as a separate chapter, as an independent act, people are realizing, oh, there is something here. For people like us, there is very little difference, except that we say 43A, and along with that, whatever came as reasonable security practices guideline in the 11th April 2011, we say that that was already there for 10 years. Now you are trying to expand it into 99 sections in this act, trying to give more clarity. So it is an evolution of 43A. There is nothing more to it. And after this law becomes effective, section 43A will be removed from Information Technology Act. And when this act becomes effective, when the parliament passes it and the president gives his assent, there will be an authority called Data Protection Authority. And the Data Protection Authority will continue to provide notifications and regulations, which also become important aspects of the law. This is how the data protection law will evolve. Now, we expect that even after the notification of the DPA 2021, government may give about 2 years time for its implementation. So until that time, that is not only from 2011, 2009 to 2021, but from even now from 2021 until about 23, 43A of Information Technology Act continues to be the main law which is enforceable in India. So that is what people should remember. You are not learning anything new today. You are only relearning what was already there. So if our education system has not taught data protection under 43A, we are 10 years late. Only thing is DPA may give more clarity. Now, the data protection bill, which we call as DPA 2021, is a law which is applicable across all industries and all types of organizations. It will apply to educational institutions, colleges, as much as the IT companies and the government. Okay, just as ITA 2000 was a law applicable across all documents called electronic documents, which are binary expressions, DPA 2021 also is a cross-industry or cross-sector law. And it will be applicable for collection, processing, disclosure, or disposal of personal data in general. It will, of course, supplement other laws. In an educational institution, an engineering college, is personal data of students as well as personal data of employees are the subject matter of this data protection. So the first thing which you should look at is, where is the data protection governance in your organization? So before you start teaching the students, you must ask yourself a question: who is the data protection officer of your college? Just as we said, when Information Technology Act came, there should be a grievance officer, his name should be there in the website. Today, it is necessary for a data protection officer to be named as a person, unless, of course, you get some exemptions in the Data Protection Authority. We do not know. When the details come, we will like to know. But remember this, the responsibility will come back to the IT department, because engineering college doesn't have a law department. Okay, or say whether you call it as information security or computer science, somebody will come and ask, what do we do for being compliant with data protection law? So be ready for that. One difference between ITA 2000 and this is, in ITA 2000, penalties were applicable only when there is a cause of action. That is, somebody should have suffered a loss, he should go to the police or he should go to the court. Then it will come into being. Whereas under data protection law, a data breach is not essential for a liability to arise, because DPA is a compliance law. It says that you have to be compliant like this. If you are not compliant, then you are going to suffer a consequence out of that. I already covered this aspect of DPA already being effective. So whatever we are talking of today is something which you should have done 10 years back. Okay. Now, this 10 years back, 43A had a concept called due diligence. And I am saying that this entire Data Protection Act is part of that due diligence requirement, because 43A said you have to have a privacy policy, you should have collection principles, and even cross-border transfer was covered under this 43A, and all the security practices. So we are talking of an implementation which should have been done 10 years back. And as I say, it is also applicable to you as an educational institution. And without waiting for the law to be passed, I would like most of these organizations to start working on it. Now, this act has got 99 sections divided into 14 different chapters. It is just a overview of this for you to understand it. It will talk about applicability, definitions. It will say what a data fiduciary has to do and what are the exemptions for consent. How do you handle children's data? In engineering college, you may not have children's data, but there are other schools, children's data will be there. Children means a person less than 18 years of age. Then what are the rights given to those people, that is the data subjects, whom we call as data principals here? What kind of accountability is there? Whether you can transfer it outside India, and what are all the exemptions? These are all things covered in different chapters. There are penalties and offenses. Data Protection Authority is the authority which has to implement this. All this is available in the Act, which is a legal provision. May or may not be relevant for you to go into the full details, except for the DPO. If whoever becomes a DPO, he should know this law thoroughly. So if tomorrow your organization says, let the HOD of IT becomes the DPO, then you must also be aware of all this law. Okay. Now, what is the key concern? This is what one of you was asking as a question. What will happen if I am not compliant? Now, that is what we call as risk of non-compliance. The financial penalty is maximum of 4% of the total worldwide turnover of an organization. Of course, there is another limit called 15 crores, but whichever is higher. So 4% of total worldwide turnover is the criteria for companies. And there are certain way by which it is computed. There are certain things for which there is a penalty of 2%. So you can say there are certain things which are 2% penalty risk, certain things 4% penalty risk. Just see what kind of things can result in a 2% penalty, that is 2% of the global turnover, or 5 crores, whichever is higher. One is failure to register. That is, after this act becomes say effective, if an organization or a type of organization requires to register itself, failure to register can lead to 5 crore, up to 5 crores penalty, or up to 2%. Failure to appoint a data protection officer, if you are considered significant data fiduciary, which a college is. Now, failure to conduct what is called a data protection impact assessment, a preliminary audit whenever some new software is being used. Failure to take action when there is a data breach. Any of these things can result in penalty up to 5 crores. There are greater things like if the personal data is being processed in violation of the legal basis, not adhering to principles, and security not being properly followed, transferring of the data outside India in violation, they may result in 4%. Remember, in the corporate circle, recently Amazon was fined by the GDPR authorities to the extent of $887 million US. So that is the extent of penalties which are happening, which will also perhaps happen in India. but it is left to the discretion of the data protection authority. Initially, they will have only a nominal penalties, but as you go along, they may increase it. There is also a potential criminal liability, 3 years imprisonment. This is applicable mostly to all the data scientists or data, say big data companies, because this involves re-identification of a de-identified information. You know that personal data consists of identity related to a person and then the data. For example, a health report of Mr. X. So who is Mr. X is the personal data, and the health report is the health data. Now, a company or an organization may disclose it to somebody else without saying who is Mr. X. That is what we call as the de-identified information. Now, if some other person says, I am a very intelligent software person, I can re-identify what you have de-identified, I have got an algorithm to do that, etc., etc. Then using such processes by which you re-identify a de-identified information without the consent of the data subject could result in 3 years imprisonment, which means that any organization which is involved in such activity should be careful. And whenever such criminal liability, see, in the case of civil liability, the organization has to pay. In the case of criminal liability, you cannot put the organization in the jail. So person in charge of the organization becomes potentially liable for imprisonment. So this is the risk. So the question which one of you raised, how mandatory it is for corporate to be data privacy compliant, is answered by the fact that if you are non-compliant, you may have to pay a fortune as penalty. And if your luck is bad, the CEO of the company, any of the directors of the company, the data protection officer, or any person in charge of business, any of them could be liable for imprisonment. Okay. Now, with that, if you now look at to whom this act is applicable, that is the applicability clause, we see that one basic applicability clause is that this law applies to the processing of personal data collected, stored, disclosed, shared within India. Okay, so this is the data-oriented applicability. If you are engaged in processing, processing includes storage. So collection, everything is included. So if a data is being collected in India, this act is applicable. Second, if the organization is constituted under Indian law, like a company or a society or something started under Indian law, then whatever is its data processing activity, that is any personal data processed by an organization which is constituted under Indian law, then this law will be applicable. Then, in case the organization is not established in India, it's a foreign organization, in certain circumstances, that organization will also be coming under the provisions of this law, in case they are doing some business with Indian data subjects or data principles, and maybe they are profiling the Indian companies. Now, only in respect of one aspect called reporting of a data breach, this law will be applicable even for a data breach of non-personal data. Otherwise, most of the applicability is for personal data. Now, when you say personal data, it is data which is leading to the identity of a person. That is the basic aspect. And the person is referred to as data principal. The organization which determines the collection process and determines why I want to collect it and how I want to use it, that entity is called the data fiduciary. Sometimes a data fiduciary subcontracts processing work to somebody else. That person is called the data processor. Most of the liabilities are with the data fiduciary, and the data processor is bound by a processing a contract between data fiduciary and the data processor. So that is how there are three important parties to the applicability: data principal, data fiduciary, and data processor. Now, what are the obligations of data fiduciary? This is explained in chapters 2 to 8. 2, 3, 4, and 8 talk about general principles of data processing and the exemptions. Chapter 5 talks about what is called rights of data principles, and 6 and 7 talk about the accountability of data fiduciary. This which also apply to the educational institution. Just briefly looking at the obligations, the principles of data protection is: first, data can be processed lawfully as given in this act only, not otherwise. And there has to be a purpose limitation, that is, collection of data should be for a specified purpose. Collection should be limited to what is required for the purpose, that is collection limitation. Notice has to be given before collection. The data has to be kept accurate. Then it should be retained only as long as it is necessary, not later than that. The person who is collecting is accountable for the entire process. And one of the things which is considered a necessity is the consent. That is, you give a notice and then have a consent. Similarly, there are rights given to the data principal. One is, if somebody has collected your information, you have got a right to ask him at some point of time, do you have my data? Can I access what information you have? That is called the right of confirmation and access. Then I can also ask you, please correct it, there is something wrong. So there is right to correction. I can ask you to erase the data if the purpose for which it was given is over. I can ask you to transfer that data or port that data to some, either back to me myself or some other entity. And there is also something called right to be forgotten. That is, once and for all, you try to erase all instances of data. So these are the four principal rights. Some associated rights are also there. That is, right to receive a notice before you ask and get my consent. And my consent, I should be able to withdraw. Then if there is any grievance, I have got a right to grievance redressal. I have got a right for nomination of how my account has to be handled after my death. Right to compensation, going to the court and asking for monetary compensation. This is different from the penalty which the regulator is going to put on an organization. Say, regulator may say a particular organization, you have not been compliant, so pay 2 crores. That is different. But I, as a data subject or the data principal, may ask the same institution, because you did not comply with the law, I suffered 25,000 rupees loss, so please pay me that 25,000 rupees. So right to compensation is for the individual, and right of penalty is imposed on the organization. Then right to collective representation is the public interest kind of litigation can be filed. Then cross-border transfer, I can try to restrict, say my data, don't send it to China, kind of a thing. Right to use an intermediary called consent manager. I can tell a data fiduciary, please talk to my consent manager. He will give my consent. And if I ever have to exercise any rights, he will talk on my behalf. That is a right. So 4 principal rights and 8 additional rights are guaranteed under this particular law. These principles, which I said here, and these rights, all these things become part of the responsibility of the person creating the technology architecture for ensuring that by default, privacy by design, okay, all these 12 rights and these principles, they are adequately taken care of. Tomorrow you should not say that my software is not capable of doing this. Okay, so that is how the study of this law is relevant for the software developers. Of course, having said that consent is mandatory, the law also talks of certain cases in which the data can be processed without consent, which is like an exemption. Basic exemption is one of the exceptions is for the government when for the function of any state, it has to collect the information, then consent may be excused. If there is other legal requirement, medical emergency, epidemic, these are all some of the situations in which consent is exempted. Now, coming to the private sector, on the employment, there are exemptions. That is, for recruiting, terminating, or provision of any service benefits, verifying the attendance, assessment of performance, or any other employment-related requirement where getting this consent becomes impossible or having a disproportionate effort, there are consents, which means that the exemptions are not given only to the government departments, as sometimes are projected by media in the last few days. If you see, we have people are criticized this law saying government is trying to take over everything, but government has given enough exemptions even to the companies. So this entire employment, this thing is applicable for the companies. Additionally, along with this, there are other reasonable purposes under which companies will be given exemptions of consent, some of which are specifically mentioned in this section 14, like if you are having fraud prevention activities, then you don't have to take consent. Whistleblowing, mergers and acquisitions, information security, credit scoring, debt recovery, and also publicly available personal data can be processed without the need for prior consent. Okay. Now, this is something which is available in India, maybe not in other places, but whenever we take public data, we have to also keep in mind that sometimes we make public data public for a particular purpose. And if I want to use it for a different purpose, it's always preferable to take a secondary consent. But anyway, some concession is there. So what I would like people to understand is that though there is a heavy criticism that this bill is actually is something which the government has got too much of powers, there are exceptional exemptions available to the private sector, and that is the balancing act the government is trying to do. Okay. Now, whenever such reasonable purposes are to be used, of course, there will be further regulations which the Data Protection Authority will perhaps provide. Then as far as the personal data of children is concerned, normally one aspect is the parental consent is required. The the minor cannot give a valid consent, for which purpose there has to be a age verification. So from technology perspective, what you have to worry about is how do I verify the age of a person from whom I am collecting the data. Now, without collecting the data, I don't know whether he's a major or a minor. And if he is a minor, then immediately I have to tell him that your consent is not sufficient. I want parental consent. And this is, of course, more relevant when we have a service which is directed towards minors. For example, your Byju's or something like that, which is for, say, K-12 education. We know that basically you will have people who are minors only. So there, this age verification must be perhaps one of the criteria to be built in. Normally, this details of how or where this age verification, other constraints will be applicable, will be determined by the authority, taking into account the volume of personal data, which will be processed by that particular data fiduciary, etc. Okay. Now, but even when you are permitted to handle that personal data, profiling is not permitted, tracking is not permitted, behavioral monitoring is not permitted, targeted advertising is not permitted. These are some of the restrictions which the data fiduciaries will have to abide with when processing the personal data of children. So now we have seen the general data processing principles, the rights, both of which will have to be taken into the technological architecture. We have seen the exemptions available for consent and also the restrictions or otherwise of children's data. Now we will go into more of technology related requirements. Elsewhere in GDPR and other laws, people talk of privacy by design, saying that by default, the privacy should be protected. and any permissions which are required should be through opt-in. So that is what is considered as privacy by design. India goes one step further and says, please put it down in writing. What is your privacy by design policy? And the owners will have to sign that and then submit it to the Data Protection Authority, get it certified, and it has to be published also, both in the Data Protection Authority's website and also in the website of the Data Fiduciary. If you look at this, those of you who know that whenever a financial mobilization is done through what we call as IPOs. For example, tomorrow LIC is coming up with an IPO. It has to actually develop something called a prospectus and make that prospectus available to anybody who wants to invest. In this prospectus, we say why the money is required, how it will be used, etc., etc. And same way, the Data Protection Authority, the law in India considers that before you raise personal data from the public, tell him how and why you raise it and how you are going to use it by means of a prospectus of personal data collection. This is a very unique proposition, first in the world. Okay, so Indian Data Protection Act has got a concept which is much, much broader than the GDPR, and it actually protects the interest of the data subject or the data principal. Of course, this privacy by design policy has to contain a lot of things. This is a matter of administrative requirement. And this is the challenge which the companies will have to do. Maybe if you are, some of you are going to be responsible for having this privacy by design policy for your college, then you have to see the details of what are the things which are required here. Managerial, organizational, business practices of your college, and what are the obligations you are undertaking as a data fiduciary, how you are collecting it, how you are storing it, how you are deleting it, and so on. What is the technology used? What is your legitimate interest in managing this data? All these things are part of this, and developing this privacy by design policy is a highly, you can say, expert job. More than this, anytime you are using a new technology or a new process, there is something called data protection impact assessment, which you have to be prepared. This is process specific, project specific, and you have to make an assessment of what kind of harms may be caused. And then if necessary, you should talk to the Data Protection Authority and take permissions. Our Indian law also says that we don't want you to hide behind algorithms. Okay, even if you are using an automated say software and say that I don't know what the software does it, I give the input here, I take the output here, the law says there should be algorithmic transparency. We don't want black box processing. Explainable AI is perhaps the default norm, and there has to be audits like bias audit conducted or algorithmic audit conducted for automated software. In addition to this, any hardware, software used for personal data processing needs to be certified for security. There is information security certification is mandatory for their use in the data processing, that it doesn't contain any malicious software. So for which certification labs are expected to be set up all over the country by the government. And that is something which, as engineering institutions, you should try to promote. A software hardware certification agency in your place, collaborate with a government agency, develop a research and development, and provide certifications to all the users. So this is one of the things which are possible for technology organizations. Next, we will come to the data protection officer, which is a new career building opportunity. Now, what Indian law says is that the data protection officer will be at the level of what is called key managerial personnel. When we say key managerial personnel in a company, we are really talking of the CEO, company secretary, whole-time director kind of a thing. So the DPO will be in that grade in a company. And that DPO will have responsibilities of monitoring the data processing activities, maintaining the records, providing advice to the company, providing advice on data protection impact assessments, providing advice on the privacy by design policy. In addition, externally, the DPO will act as a point of contact for data principals, which also means that he will be the grievance redressal first contact. He will also provide assistance and cooperation to the Data Protection Authority. So he will have external obligations, internal management responsibilities, and these are the functions, a very, very important duty for the data protection officer. And this is what the law says. Briefly talking about restrictions on transfer of data. Again, this is a point on which media sometimes says that there is a lot of inconvenience caused to the industry, but actually Indian law does not have any too much of restrictions on transfer of data, because non-sensitive personal data can be freely transferred. Sensitive personal data can also be transferred. Only thing is you have to keep a copy in India, take an explicit consent. There are also other aspects like prior contract and other things. And under emergencies, even critical personal data, which has not yet been defined, can be transferred. So there are very little restrictions on the transfer of data outside India. If at all anybody talks of data localization is there in Europe, in the EU GDPR, not in Indian law. There are a number of exemptions available, which is, of course, one is government can exempt some agencies based on the constitutional requirements. Okay, then certain kinds of processing can be exempted. Certain data processors can be exempted, particularly those who process foreigners' data sitting in India. The government may say that I will give you complete exemption from the act, which means there is a total exemption possibility for an Indian corporate entity. In fact, that is much more than what is the power of the central government to exempt itself. So again, this actually shows that many of the criticisms, including something which appeared in Economic Times a couple of days back, they're all fake reports, are reports based on wrong understanding of the act. There are as much exemptions to the private sector as the private public sector. For research, for small entities, for encouraging innovation, there is a 3-year sandbox kind of an arrangement coverage. So there are a lot of exemptions. I don't want to go into the details of the exemptions because these are a matter of detail, but you can see that it is available for different purposes, including BPOs for research, etc. Now, there are a couple of institutions which will come into existence. One is the Data Protection Authority. There will be an appellate tribunal. There will be an adjudicating officer who will take the grievances and then give his decisions, which can be appealed to the appellate tribunal, and appeals from the appellate tribunal will go to the Supreme Court. So that is one set of things. Data Protection Authority will be overall in charge. Within Data Protection Authority, there will be inspecting officers. Adjudicating officer also will be working along with that. There will be independent data auditors who will be required to conduct data audits mandatorily once in a year for certain kind of data fiduciaries. I can assure you that your college will be a significant data fiduciary, which will require mandatory annual data audit from a third party and concurrent auditing during the year. And also a data protection officer who will be within the organization for continuous monitoring of the whole process. So the legal authority will flow from Supreme Court, appellate tribunal, and adjudicator. Administrative authority will be from the Data Protection Authority through the inspector. Both of them may be dealing with the data protection officer and the companies or organizations. Audits are required: mandatory annual data audit, concurrent audit, DPIA whenever new technology is used, harm audit whenever there is a conflict of interest between the right of one person for privacy versus another person, then algorithmic audit, hardware and software security audit. These are all required under the Act, and existing frameworks for compliance which maybe ISO 27001 or 27701 will be inadequate for this purpose. You should look at something called Data Protection Standard of India, which FDPPI and other organizations are promoting as a code of practice, because the law provides for code of practice. For example, all educational institutions can have a code of practice applicable to you. All engineering colleges can come together and say, develop a code of practice, and then try to get that approved from the Data Protection Authority. So we in FDPPI, which is Foundation of Data Protection Professionals in India, have developed something called DPSI, Data Protection Standard of India, as a open standard compliance framework, which is encompassing the ISO 27001, 27701, and IS 17428. It is bigger and better than any of these IS standard, ISMS protection standards, because we are focusing more on the compliance of this law. See, ISO 27001 is a measure of ISMS, and 27701 is a measure of the PIMS, Personal Information Management System. And our DPSI is a measure of how well you are complying with the Indian DPA 2021. Because during this audit, we have to also come out with something called a data trust score, DTS, which is like a final number which is assigned to a company's maturity of, say, data protection. And this DTS score will have to be published in the notice, published on your website. And for that, our Data Protection Standard of India compliance, DPSI, provides a method by which it can be done. So, okay, this is directly focused on DPA 2021, incorporates compliance of even ITA 20000 and other GDPR and other laws as a unified process. So, as a summary, before we get into the questions, I would just like to say, privacy is a right protected as a fundamental right, but it is protected as information privacy through data protection. And the laws prescribe certain obligations of the data processors or the data fiduciaries. It is enforced through an appropriate regulator and a system of penalties. And data protection laws normally apply to personal data, while some aspects of non-personal data are included here. Most of the non-personal data aspects are covered under ITA 2000. That is why we have combined the two and say that DPSI will combine both the two. And though we may, of course, wait for the Indian Data Protection Authority to come up with whatever provisions. It is now empowered to take over non-personal data, but I don't think they will do it because ITA 2000 is already in existence. There is a CERT in which is already regulating it. So there will be a coordination between CERT and this Data Protection Authority as sectoral, you can say, regulators, and they will try to manage the whole system. Okay, so this is what I wanted to share now. Then we will go into the questions, and if you have more of any doubts, you are welcome to raise it. Let me first see what are the questions.
Yes, sir. There are few questions posted by the faculties.
Yeah.
So let me read it for you. The first question is, which data is important as college point of view? Which data as a faculty we can keep as important, because lots of data is created. Sometimes it is unable to keep data.
The first task in compliance is to understand what data we are having. That is the question also indicates that first thing is what kind of data I'm having. One is the personal data. It is easier to identify the personal data. Personal data will be personal data of students, current students, past students, including their educational performances, marks card, and other things. So there is a personal data involved there. Then there is corporate data, which is which has to be protected under Information Technology Act. So that is non-personal data. Now there is something called anonymized personal data, which is also non-personal data. What we mean by anonymized personal data is something is there as a personal data where identity of a person is there, but you try to destroy the identity features irrevocably and convert it into a anonymized data, which is actually a feedstock for big data and other things. Okay, because it captures the characteristics of the data subjects involved there, but without identifying. It is the surveys and other things. If you want to create a survey that how many people who did well in first semester finally continued it for all the 5 semesters. Now you can create a report of that, which actually processes personal data, but the final survey need not have the identity. So anonymized personal data. Then in e-commerce and other things, we have something called transaction data. Now here also you will have such transaction data. What I mean by transaction data is there is a data subject, he undertakes a transaction with you. For example, I make a payment to Amazon. Now that payment information, Amazon cannot say it is my information, corporate information. You also cannot say it is your personal information. That is jointly owned by the 2 parties. So like that, information has to be segregated into personal data, non-personal data first. And personal data can be of students as well as the teachers, as well as the parents of the students. Now, teachers become employees. So you may have to have a category called personal data employees, personal data students, personal data parents of students, because the degree of security and the problems will be different, because the parents will interact only once in twice or thrice in a year or something like that. Whereas students, it's a day-to-day, this thing, attendance monitoring is there. There will be CCTVs within the premises. So it's a continuous monitoring of the students as well as the teachers. I am sure that many colleges have got CCTV within the classroom also. So you have to first categorize this. Now, personal data processing is the focus of DPA 2021. Non-personal data still has to be protected because of the ITA 2000, that is the information security, which you might have already introduced. But if there is a data breach in the organization, then the reporting of the data breach should include both personal data and non-personal data. Other than that, what is important is personal data. Now, out of that personal data, what is more important is I will put the parents' data as first, students' data as second, and then teachers' data as the third. Why? Because teachers can be bound by an employment contract. You can take some extra, permissions and other things. Students, their data is required to be processed as a part of your legitimate interest. Okay. Personal data of the parents and other things, you have only minimal rights to use. So if there is a data breach of the personal data of the parents, the damage can be more. Okay. Does it make sense in categorizing the data? Okay. There is importance. Now, if any
second question, sir.
Yeah.
If any personal data is processed by student, which is by utilizing college resources with violation of some privacy law, then what should be done by the college to handle such situation?
Maybe you can try to link it to the activity of an employee in an organization. Okay. Now, is the student authorized to do that for a specific project? For example, you have given a particular, say, annual event to be done, something like that. Then it is on permission. Okay, that is the college first gives permission to somebody to collect and process personal data, and he has to process it within that particular permissions. He should not misuse that information, then he will be liable personally. Okay. But for the processing, for example, you want to conduct an annual event, you want to ask all your students who is good in dancing, who is good in singing, etc., etc. You have to collect personal data from all the students. So you send a circular or put an online website, collect all that information. Now, at the time of collection, first of all, you should get the consent of the particular student saying that we are collecting this information to identify potential participants in our annual event. If you are interested, you can provide this, and these are our consent related notice. Okay, this is how we are going to use, etc., etc. And some of them you may have to say that this is not related to your educational activity. So after the event is over, the question is, do you require to know which student is interested in dance, which student is interested in music once the event is over, or at least if you don't want to use it for the next year, then it has to be deleted. So minimal collection, minimal retention, all these principles will have to be applied for that. But within those principles, the college can authorize the a particular student, like an employee being appointed or is designated for a project, to process the personal data. He should use consent for collection of the data and processing of the data. Use it only as per the consent. And after the event is over, then a legitimate interest is, if it is a first semester student, next year we want to conduct another project thing, I want to see who are all good in music or something like that, then you may have something called a legitimate interest of retaining the data about a student up to the time he remains a student. Now, there are other data like marks card and other things which you have to retain permanently. I am only talking of this some personal preferences and other things which you have collected for this activity. I say that you have to put a data retention policy saying that this will be deleted after the person completes his course and leaves. I'm not going to delete his what he has studied, etc., etc. All the student related details will be there, but this extracurricular activity details I may not require after the person goes out of the institution. So such principles have to be put into the collection mechanism, and then it can be processed. Okay.
Yeah, I hope the people who are asking the questions are getting their answers satisfactory.
Okay.
If not, you may.
Yeah, they can write
unmute.
supplementary questions.
Yeah.
Otherwise, I will go through the next questions. I am seeing the chat box here. Now, qualification and certification required for data protection officer. I have given you the DPO's responsibilities, so you should look at it. Basically, he should be aware of the data protection law in India. And for interpreting the data protection practices in India, some knowledge of the GDPR and international laws is required. He should have a reasonable exposure in understanding technology. He should be able to have behavioral, say, skills to deal with the peers in this organization, external people who are the data subjects, and to also go and meet adjudicators and even the data protection authority. So it is a very big responsibility. So there is no specific qualification in, for example, in organizations like ours, FDPPI, we have created a certification program. In the certification, one module is on Indian law, another module is on international law, third module is on the audit skills, and together we are giving a certificate like a certified data protection officer. Now, when the data protection authority comes into being after the act, the data protection authority may give us some guidelines of what they expect from a data protection officer. At that time, perhaps we will have a clearer understanding. But as of today, if you want to know about the qualifications, whatever we have put in our curriculum for DPO, certified data protection officer, we consider it as the requirement of a data protection officer. Beyond this, we will wait for the government to actually come up with a guideline. They will come up with a guideline not only for data protection officer, but also for data auditors. That is, what is the accreditation criteria, whether there will be a separate examination conducted by the government for that. All those things we have to wait and see. Now, log4j security vulnerability, it may or may not be a privacy issue. It may be a security issue, or this may be a security failure which leads to a privacy failure. So probably you should, if you consider that as a issue related to the security of access, okay, say even data protection, if you want to say personal data has to be protected from confidentiality, integrity, and availability, the access to personal data has to be given only to persons who have the need to know. I told you about this project. If you appoint a student to take care of a project, you give him access to certain information. Likewise, it is a accessibility created for a specific particular reason. If there is any supporting software where security vulnerability has arisen, indirectly it will lead to data protection failure also. So probably if it happens and because of which personal data is breached, then you have to be ready for penalties of that. Otherwise, you should handle this more like a security issue, mostly perhaps as a cyber security issue. Okay. Now, can we consider the targeted ads of social media site as a breach of privacy? You can say it's an indication that your preferences have been profiled by the social media. Okay. Now, it's possible that you yourself might have given the permission for that. So if you have given the permission, then it will not be a violation of privacy. Now, where will you know whether you have given a permission? You should go back to see when you became a when you took the Facebook account, what was the privacy policy which you read and signed? If it already has an element saying that we may use your data for such and such a purpose, then there is no breach of privacy. But if you see targeted ads, it's an indication that your profiling has been done. Now, whether it is harmful to you or not, you have to separately evaluate it. There are many instances where it may not be causing a significant harm. So even if you want to say privacy has been breached, how much of compensation you can claim or not and other things are secondary issues. Now, what things are to be considered if we want to pursue professional career? You are already in the technology domain in a way, and if I am looking at you as faculty, you have a reasonable expertise in information security, but you might not have had exposure in the law side, and the audit and other things are a different kind of skills. So the first thing is you should try to enlarge your skills. One option I would like to reiterate is please visit the website www.fdppi.in, which is our site. And of course, a lot of information is also available in Naavi.org. Now, if you go to fdppi.in, you will see fdppi.in is a Section 8 company. It's not a government company. It is a private sector kind of an activity only. Okay, but 3 years before today, that is, if the act comes in the next 1 or 2 months, I can say that in 2018 itself, we started this FDPPI and then tried to create it as a foundation of data protection professionals. We took upon in conducting the training programs on the Indian law before the law became an act, and then of course also gave a lot of information and knowledge on international laws and secure skills on auditing. That could be the starting point. As I told you before you started, we were the first to start this in FDPPI. Other organizations will come in shortly. In fact, certain law institutions have started only now, for which also I am involved in some way to create curriculum and other things, but they have started courses on data protection law. So in another couple of years, there will be many more such people. FDPPI will be only an organization, private sector organization. There will be colleges which will be giving a certificate in, let us say, data protection law. Now, as far as the auditing is concerned, it is a skill. It is not easily taught. We may teach certain principles, but you have to pick up that as you go along. But if you are looking at it as a career, what you can acquire as say knowledge and skill from outside is the law aspect, then some technological skill, like while implementing this, you should know about access control, you should know about anonymization, you should know about the use of software for classification of data. So some of those technology things, which I'm sure you will all have more than required exposure, that is also required anyway. If I am talking to a law person, I will say, you please acquire these things. Then look at this audit requirements. What is audit requirements? Audit requirements is verification of the requirements of this law in actual practice. We try to do that in our training programs. We even try to say what is data trust score, how it can be arrived at. We have got a framework called DP, that is Data Protection Standard of India. You must explore that DPSI. We originally called it as PDPSI. So there is a reference on PDPSI earlier. Now, because this new law has combined personal data and this, we have renamed it as DPSI. This is a framework. If you are an expert in this framework, I say you are ready to be a data protection officer. And whatever we are doing, we are trying to drive people towards that. As of now, there may be no other formal course. We have done that now, and maybe when Data Protection Authority comes into being, they may come up with their own say criteria. I don't know. There are certain government organizations. They can even introduce their own training programs. Okay, but that's all in the future. Okay, so that is how you can build up a professional career, techno-legal domain. So you should know law, you should know technology, and then have some skills. Okay. Now, last question, perhaps. Often the achievements of students is shared, disclosing the identity photographs on the college website. So this is part of the consent which the college should obtain, even at the time of admission. See, today at the time of admission, you have to do so many things. I'm sure that presently the colleges are not equipped to do this. Sometime back when we were all students, there was nothing. Okay, you are expected to come to the class and then go out. Okay, there was no other rights and other things. You have to pass the examination. Today, we need consent on the dress code, etc. And now these things also become part of the notice. You have to say, as a college, I would like to use your identity. If you are my best student, and if I can take mileage out of it, it is my marketing. So if I want to use it, I should either get a consent from you specifically, or I should incorporate it in the admission consent. It is not exempted by privacy law. If you want, you can get exemption by making it a legitimate interest or by specific permission granted to you. Like Facebook takes your permission when you become a member. If you don't want to give that permission, you will not be a member. So like that, I will introduce my code in the admission this thing itself, which may include that I may use your education related data, not anything else. But if you are having the education data, this normally happens in private, say, tutorials and other things, not in major colleges. But sometimes you may have to project your students, because that is the indication of your college reputation. So if you want to have it, one, have a provision in the admission consent. Then when you want to specifically use it for something, please take the consent. That is what I would like to suggest. And consent has to be written, and written consent also means electronically written consent. So please take it. And this consent has to be kept with you, tagged to this activity, because anytime later somebody may ask, did you take the consent? So don't just throw it off. You have to have in your database the consent information. Okay. Currently in India, the security auditing process make data protection auditing mandatory. See, whenever people actually design a process, they will have one clause. For example, in ISO 27001, somewhere it will say all applicable laws have to be complied with. So if you look at it that way, ITA 2000 compliance is also required. DPA also is required. Now, tell me how many people who do ISO 27001 will take information technology, ITA 2000, audit as part of ISO. They don't really look at it. At best, they look at IPR. So if you say a framework, if I'm designing a framework, somewhere I will add, say like, if we are having the data protection standard of India, it is focused on privacy, but it also has got information security, and in a way, ISO 27001 will help there. So ISO 27001 should, by design, help in DPA compliance, and DPSI by design should incorporate the principles of ISO 27001. So designing is done like that. But of course, ISO is a certifiable framework for which certain criteria is fixed by the certifying agency. DPSI is a certifiable process for which FDPPI fixes the norms. So that may be slightly different. So as of today, I can say in ISO 27001, the data protection aspects are not focused. You know that currently there is a new version of ISO 27001, 2022 version, where there are certain provisions related to the data protection. So if somebody faithfully implements that, maybe you can say data protection is part of that. Okay.
Yes, thank you, sir. I think we have done with all questions. One more is there. ISO 27001 new version is yet to be released by ISO.
Right, but I think some drafts are already circulating in the this thing. But that is the aim. They want to combine the 27701 with the 27001 perhaps. But what I'm saying is that that is the direction in which the ISO is also moving. So it will be there. And when they say the legal provisions, agreed, ISO 27002. Okay, the controls are modified controls are there in ISO 27002. Fine. Okay, so when actually in the new controls come, it, for example, even in the current this thing, okay, the list of laws which a company is trying to, let us say, comply with, will have to be determined by the auditor. So if a person is intelligent enough or knowledgeable enough to add ITA 2000, add DPA 2021 or whatever is that, then it becomes mandatory. Okay. If he wants to ignore that, most of the ISO auditors today are not considering ITA 2000 audit as part of ISO audit. So that system will continue as an inefficient system. Okay.